Imagine a company with a paid-up capital of only a few lakhs. Now imagine that same company collecting more than 24,000 crore rupees from nearly 3 crore investors across India without an IPO, without stock exchange listing, without complying with the disclosure norms applicable to public issues, and while doing so, claiming that this was merely a private placement. Sounds unbelievable? Yet, this is exactly what happened in one of India's most important securities law cases, the Sahara versus SEBI case, a case that reshaped the law relating to private placements, public issues, investor protection, and SEBI's regulatory powers. But here's the real question. How can an issue offered to millions of investors be called a private placement? And why did the Supreme Court ultimately direct Sahara to refund thousands of crores of rupees? Stay till the end, because this judgment is not only a landmark case for CS executive and CS professional students, but also one of the most important investor protection rulings ever delivered in India. Hello everyone. Welcome to Corporate and Securities Law Compass. Today we are discussing the landmark Supreme Court judgment in Sahara India Real Estate Corporation Limited and Sahara Housing Investment Corporation Limited versus SEBI. This judgment is a must-know case for every student of company law, securities law, capital markets, and corporate governance. Let's understand the facts, the legal issues, the arguments, and the Supreme Court's reasoning in simple language. The facts. The story begins in 2000. Two Sahara Group companies, Sahara India Real Estate Corporation Limited, known as SIRCL, and Sahara Housing Investment Corporation Limited, known as SHICL, started issuing optionally fully convertible debentures, commonly called OFCDs. The companies claimed that these OFCDs were being offered through private placement. According to Sahara, the offer was made only to selected persons associated with the Sahara Group. The companies also clearly stated that they did not intend to list these securities on any stock exchange. On paper, everything appeared to be a private placement, but reality told a very different story. And this is where the case becomes explosive, because the so-called private placement eventually reached millions of investors, not hundreds, not thousands, millions. The massive fundraising. The Supreme Court noted that Sahara collected enormous amounts from investors through OFCDs. The issue reached over 2 crore investors and involved collections running into tens of thousands of crores of rupees. SEBI became concerned. The regulator asked a simple question. If the issue was truly private, how did it reach such an enormous number of investors? This question triggered one of the biggest regulatory battles in Indian capital market history. What was Sahara's argument? Sahara argued, "We have not made a public issue. We have only made a private placement. We do not intend to list these securities. Therefore, SEBI has no jurisdiction." According to Sahara, the matter falls under the Ministry of Corporate Affairs and the Registrar of Companies, not SEBI. This became the central legal battle. The most important legal question: when does a private placement become a public issue? This was the heart of the case. The answer lay in Section 67 of the Companies Act 1956. The law provided that if an offer is made to 50 persons or more, it would be treated as an offer to the public. This completely changed the analysis, because Sahara had approached an extraordinarily large number of investors, far beyond the statutory threshold. Suppose I tell you that I am inviting only my close friends to invest, but I distribute application forms across the country through thousands of offices to millions of people. Can I still call it a private placement? The Supreme Court's answer was clear: no. And that answer changed Indian securities law forever. SEBI's position. SEBI argued that the issue was effectively a public issue. If it is a public issue, Section 73 becomes applicable. And once Section 73 applies, The securities must be listed on a recognized stock exchange. Further, public issue disclosure norms become mandatory. SEBI also argued that investor protection cannot be bypassed simply by labeling an issue as a private placement. Substance is more important than form. Supreme Court's analysis. The Supreme Court carefully examined the Companies Act, the SEBI Act, the SCRA, the nature of OFCDs, the number of investors involved, the method of fundraising. The court held that the OFCDs were securities. The court further held that the issue was not a genuine private placement. It was effectively a public issue. Therefore, Sahara was required to comply with the provisions applicable to public issues, including listing requirements and investor protection measures. Why this judgment is landmark? This case established several important principles. Principle number 1: calling something a private placement does not make it a private placement. Regulators and courts will examine the substance of the transaction. Principle number 2: investor protection comes before corporate structuring. Principle number 3: SEBI has broad powers to regulate public issues and protect investors. Principle number 4: large-scale fundraising from the public cannot avoid securities law compliance. Exam points. Remember these keywords. Section 67, private placement versus public issue. Section 73, mandatory listing requirement. OVCDs, SEBI jurisdiction, investor protection, public issue compliance. These are frequently tested concepts in CS executive and CS professional examinations. The Sahara case was never just about one company. It was about protecting millions of investors. It was about ensuring transparency in capital raising. And it was about establishing that companies cannot avoid public issue regulations merely by giving a transaction a different label. The judgment remains one of the most significant decisions in the history of Indian securities regulation. Even today, whenever lawyers, regulators, or students discuss private placements and public issues, the Sahara judgment is one of the first cases that comes to mind. Do you agree with the Supreme Court's decision? Should substance always prevail over form in securities regulation? Or should companies have greater freedom in raising capital? Share your views in the comments below. If you found this analysis useful, subscribe to Corporate and Securities Law Compass for practical explanations of landmark judgments, SEBI regulations, Companies Act provisions, and capital market developments. Thank you for watching. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information (UPSI), confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.